This is Headnotes, a podcast from Whitehead Moncton.
Hello and welcome to another Headnotes podcast brought to you by Whitehead Moncton. Today you're joined by Antonio Fletcher, myself, head of the employment team, and Rebecca Lister, who is a paralegal in our team. The topic of conversation for this session is part of the employment law reforms that are coming in over the course of the next year or so, but a specific part about the increased employment tribunal limitation period. Now, the reason we're speaking about this particular topic is with all the changes that have been announced and that will be coming into force over the course of the next year or so. This one's probably gone a bit under the radar, but I think it's really important that employers know about it and the potential ramifications of it. So, as we said, there's a lot of big changes on the way, big headline grabbers, from the changes to unfair dismissal, not day one rights as we were promised initially, but a big shift in the reduction of the qualifying period for unfair dismissal from 2 years to 6 months, and we're doing separate sessions about that one. We've got new family-friendly rights, we've got changes to statutory sick pay, we've got a lot of trade union reform. So those are the big headline grabbers, I think.
Yeah, I agree. And I think this one was missed a little. It wasn't part of the initial bill. It was introduced a bit later on. And I think that's why perhaps it's gone under the radar. But like you said, it's really important. It's going to affect how people bring claims, when they can bring claims, and employers and employees need to be aware of this.
Yeah, absolutely. I think actually most of the conversations I've heard around this are, sort of amongst, if you like, employment law professionals rather than within the wider public, and certainly not really within, the news as such that people consume on a day-to-day basis. So I suppose the thing to bear in mind is if we track where we are on limitation periods and how that's changed over the years. When I first started practicing, there was a 3-month limitation period. If you missed the 3 months, you were a bit stuck as a claimant in terms of what you could do. And then over the years, it's changed a bit, and we've had pre-claim conciliation come in with ACAS, with the inclusion of the need to notify ACAS and participate in pre-claim conciliation, that has sort of moved the boundaries a bit and extended the time limit in which claims are actually issued. And even in that, we've had a big shift actually in the last couple of months, where the maximum period of time that ACAS can engage in pre-claim conciliation has doubled from 6 to 12 weeks. So that's quite a big shift in the time it can take from an issue to arise to a claim to be brought in itself.
Yeah, and I think if we look at why this change was brought in as well, this was to help relieve the workload of the tribunal system that, as we know, is quite backlogged. So increase this period just to relieve the pressure on that.
Yeah, and I think the counterbalance of that is actually so much more of a burden has been placed on ACAS over the years. Firstly, from the introduction of pre-claim conciliation, that was not something ACAS ever sort of engaged in. ACAS were always in the background for tribunal claims. You always had an appointed conciliator that you could turn to if you wanted to talk about settlement. But the sort of shift in almost the obligation to at least have some conversations with ACAS about pre-claim conciliation, firstly, when that was introduced, added a whole new branch of work to ACAS. But actually now, the longer pre-claim conciliations and the additional involvement ACAS have, I think, is putting a real strain on ACAS. And I think we see that at the moment in terms of the claims we're dealing with now. If you have a matter that goes to pre-claim conciliation, it used to be that very shortly after going into pre-claim conciliation, you'd hear from your conciliator, you'd probably have a couple of meaningful discussions, they might reach out to the other side depending on whether that's something you wanted them to do. Now I'm finding that actually, if you hear from ACAS, it's right on the deadline. And it sort of limits what ACAS can do meaningfully before they issue the certificate. Now we get to see what the impact of this move from 6 to 12 weeks is, and most of the ones I've dealt with recently are still on the 6-week process. But whether that 12-week extension is actually going to result in more help from ACAS or just a similar kind of service to what we have now.
Yes, whether it will actually help to settle claims at the earlier stages or whether we will still see them progressing to tribunal, and it's not really having its intended effect of relieving the burden, it's just sort of pushing it further down the line, which extends deadlines for individuals and employers. And
that's the whole point of this, really, is if it's going to be meaningful, it needs to be able to resolve cases before claims are issued. And I'm finding generally, and this is not meant as a slight on ACAS because I'm sure they're all very busy, but actually the claims that we are managing to settle between, let's say, a dismissal and a tribunal deadline are mainly because the parties are putting the work into doing it. So just having a pre-claim conciliation period or even a longer pre-claim conciliation period seems like just kicking the can down the road unless it's some meaningful work is being done there. There's no further changes to pre-claim conciliation scheduled. What the change that we're now talking about is actually the limitation period for the issuing of claims. So as we've said, the 3-month period originally from the date, let's talk about dismissal claims, from the date of dismissal, but more recently from the date that ACAS have issued the pre-claim conciliation certificate, has always been 3 months. What we're going to see actually is a doubling of that in October to 6 months, which is a real shift, I think.
Big change to what it currently is.
Yeah, and I mean, I think there's a few exceptions. Some breach of contract claims will remain at 3 months. Lots of speculation about whether that was an unintended consequence and whether it had just been missed off the list or whether it's intentional, but it seems to be progressing that the breach of contract claims stay at 3 months. But I suppose when you factor in a 6-month limitation period and a 12-week pre-claim conciliation period, you're looking at sort of 9-10 months from dismissal or from the act that's being complained about to when you actually issue the claim, which is a long time. And I suppose that's the start of the process. Never mind when the end of the process will be.
I think at the moment we're seeing cases that are going on for so many years after the event that this is only going to kick it down further. And is that really access to justice if people are having to wait that long to have an outcome to even get to a tribunal? It sort of undermines the whole process, as we spoke about previously.
Yeah, and absolutely. And I mean, if we go back in time 30 years to what employment tribunals were designed to be, and the objective of having an employment tribunal and employment claims not going to court as such, it was very much along the lines of having quick resolutions, less formal procedures, all these kind of things. And if you're now issuing a claim nearly a year after the issue in question, and then potentially facing a backlog of maybe 2 years, 18 months, that's kind of where we're operating with our local tribunal. before you're in front of the tribunal having the case heard, then that's not really what tribunals were designed to be. I think it's fair to point out that the reason the government is introducing these changes is because, in their view, it will result in more claims being able to settle without having the need to issue. Now, that's a interesting position to take, hopefully, for the sake of what feels like a very stretched tribunal system. That is the case, and they are proved right. But I think there's debate about whether that's actually going to be the case or not.
And then it would come down to ACAS as well, and whether that's still a meaningful process with these longer limitation claims. Yeah, whether that can help settle it. And I think there was some reasoning that the 3 months can be a bit tight for individuals, especially if they're dealing with sort of discrimination or harassment-based claims. And yes, that it can be hard to sort of deal with the thinking through the process of bringing a claim when you're going through them more emotional effects. But having the longer period in the long run, it's just pushing it down the line, and it's sort of lengthening the time that you're going through that emotional process.
Yeah, it is a really careful balancing act, because I often find whether you're acting for the respondent on the other side or whether you're acting for individuals themselves, there's a lot of emotional investment that goes into bringing a claim or pursuing a claim, that I'm very much of the view that prolonging it rarely helps people out. It rarely helps them to move on with their lives, and even if they go and get a job elsewhere, this is always in the background.
And I think that can be a big thing that puts people off bringing a claim anyway, when they're sort of thinking about when it could be resolved. If they're hearing years down the line, that's not going to make people want to come to the Employment Tribunal and have their claims heard. That could just be another unintended consequence of this.
Yeah. And, ultimately, whilst I think it's important that we and the law promote access to justice, the short time limit that there's always been on tribunal claims has caught people out. I think that's, sort of undeniable. And the people described as the unprepared and the uninformed, if you like, but that has helped to filter the number of claims that go to the tribunal. And you do think that actually, there are countless examples of case law where people have missed limits by short periods of time and then are just not allowed to continue. Obviously, by extending that limit, you are opening up a window to those people to make it more likely that they will hit a limit. Now, that is providing access to justice, undoubtedly, but that is also surely going to result in there being more claims in the tribunal rather than the stated aim of actually reducing what gets there. Maybe not to the detriment of individuals who sometimes get caught out, but it's a difficult balancing act. And for me, in order to meet this objective of actually reducing what gets to the tribunal, there needs to be substantial investment in ACAS in particular.
To encourage that earlier settlement as the reasoning behind this was. And without that, as you said, it's going to lead to more cases. Do you think that, obviously with the extra time scale, it's going to give people more time to prepare, gather evidence? Do you think we could potentially see the bringing of sort of higher quality cases, if you understand what I'm saying there?
Yeah, hopefully that is potentially a consequence of having more time, that people will have more time to build their cases. Even if you think of something like a data subject access request and the time limits for compliance with that, even if you put in a data subject access request, let's say just after you leave employment, there's a chance that you might actually not get the information that you've sought in time to include it in a claim. With a longer time limit, then actually it opens the door for individuals to make, if you like, strategic data subject access requests to try and gather more information, build a stronger claim. Hopefully things will be a bit less rushed, although I think you always work to the limits of the time you have to do things when you're particularly when you're involved in something that you're not familiar with as an individual bringing a claim. But it may well result in better drafted, better pleaded claims that hopefully then takes a bit of the work away from tribunals in terms of sometimes having to decipher actually what the claim is and having to have preliminary hearings and things like that around that. Tribunals are already very stretched in terms of their own resources. We have examples in recent years of tribunals just not being able to hear cases even on the day because of judge availability, because they're so stretched with their own resourcing. The other factor I think in all this as well is the wider economy and job market. And whilst we undoubtedly are in a period of time where tribunals are a bit stretched and taking time to deal with things, we're actually also in a period of time where people over recent years have actually been able to jump from one job to the next quite easily in most cases, and that's generally a deterrent to people actually issuing a claim, because if you're in work fairly quickly afterwards, the value of your claim tends to be lower. We now seem to be moving into less certain times where there's sort of indications of increased unemployment rates, less jobs on the market, people finding it a bit more difficult to find new employment. And the knock-on effect of that is if people take more time to find a job, the value of their claim is greater, and therefore the chance of them making a decision to issue a claim, in my view, increases because the claim's more valuable. And you still, at the end of the day, when you're talking about employment tribunals, there's no issue fee. There's no from an individual's perspective, unless you're paying for legal representation, there's no real skin in the game. So why not chance your hand? And if you've got more time to make a decision about how long is it going to take me to find work, is it worth pursuing, then you're probably more likely to issue again than you would be if you were operating in a tighter limit. And there's also what I call claims of necessity that I think back to earlier in my career when we had the financial crisis and lots of people being made redundant and finding it very difficult to find work afterwards, that people would just issue claims regardless of their merits in some cases, but purely because they had no other way of getting any money. They were unemployed, struggling to obviously to make ends meet, no real prospects of getting a job quickly, and you've got a window in which you can bring a tribunal claim. So most people will think, well, I'll give it a go. And that kind of claim is the kind of claim, again, we could see that increase just as, the job market becomes more difficult. We've already got a sort of cost of living crisis with everything costing more and more and more and more strain on families and individuals to make ends meet. So you can see those claims of necessity, if you like, increasing as well.
But obviously individuals would still be under the obligation to mitigate their losses. But I suppose, like you said, if it's taking long to find a job, even if they're looking, that is still time that would go towards any value to the claim.
Yeah, exactly. If you're, I think that's a very good point. I mean, if you are bringing any kind of tribunal claim, you do need to be able to show that you're mitigating your losses and trying to find alternative work. But if you start getting in the position where you're trying very hard and there's simply not the work there, then actually, if anything, that strengthens your position. If you've got, sort of 5 or 6 months of, so sort of constant job searches and applications and rejection letters that you can show to a tribunal, then it does serve to add to the value of your claim. And it's it's difficult, and from an employment perspective, looking at it from the respondent's side, I mean, we've spoken about claimants, still have this in the background, don't have access to justice for perhaps a long time. But flipping it round from the employer's perspective, you may have witnesses that you want to call to the hearing that they themselves move on in their career. So if the hearing's 2 or 3 years after an event, it may well be that some of the people that you would want to call as witnesses are no longer your employees.
Yeah, exactly. And also, it's a long time. People, if you don't take accurate records at the time of the event, you're relying on people's memory. That could really affect the response you're bringing to any claims. I think that's one of the key points for us to emphasise here is with this change, you've really got to work on your data retention, how you're collecting these, the processes you're following, making sure you're evidencing everything, because you could be seeing a claim brought years down the line that you might not then have the evidence to respond to effectively.
Yeah, I mean, that's a really good point about data retention is, up until now, we've always generally said to people, employees' data once they leave, you probably, sort of 8 or 9 months after they've left, if you've not heard anything, that's probably around the right time to sort of get rid of anything beyond what you need for pension and tax returns and basic references. You don't need to hold on to employees' data for that long. Here, certainly one action that employers will need to take is look at their data retention policies and probably make a change to say, actually, the basic period of time in which we will hold on to all employee data now is probably going to be more like the 18-month mark. I think that's probably reasonable now. So it's a significant increase upwards when you factor in the extension to the ACAS limit plus the extension to the limitation period. You also have to start thinking about things like insurance cover. Does your insurance cover the potential longer window for a claim to be brought into? And then I think just general good advice is actually make sure your grievance and disciplinary processes and any appeal processes, capability processes, all those kind of things have been looked at properly, or as robust as they can be, and that those that use those processes, the managers, the team leaders, the HR team, have sufficient training and knowledge and understanding of them to do so properly. I think those are all useful action points for employers to take. I suppose to sort of round off, one question I've had and thinking about this is actually this change in the limitation period coupled with the changes to the ACAS process, the change that we may see in the job market, in the economy in the next year, 2-3 years, or who knows how long, could this actually lead to more impact than any of the other changes that are coming in, which are huge and significant, all on their own. And, I do actually think in terms of impact, in terms of claims, in terms of risk of claims, this is, possibly slightly less impactful than the big reduction in unfair dismissal qualifying period requirements, but it's up there.
And I think when you couple them up together with the extended unfair dismissal rights, and then this as well, it just adds extra risk for employers. It's just all about being on top of your processes, making sure your managers are trained to deal with issues when they occur effectively, to stop the risk of going to tribunal and these claims occurring.
Yeah. I think that's exactly right. I think be prepared, think about training, think about policies, and look at updating what you need to update to reflect this sort of shift in the landscape. I think that's a good point to round off on. And thank you very much for attending this podcast, and look forward to updating you again on some of the other changes that are coming along the way.